Good evening, everybody. Welcome to our next installment in the series on religious liberty here at Markham Church. We're glad to see the folks that are here in person, and we know that there are people online as well. Let's begin with a word of prayer, and then I'll have a couple of announcements, and we'll go right into the program tonight. Let's bow our heads. Father in heaven, thank you for bringing us here safely tonight and for the blessing of living in a country that is dedicated to giving us the freedom to worship in so many places and in so many ways. Be with our meeting tonight, we pray. In Jesus' name, amen. It certainly is nicer to be here tonight than it was where we were last week at this time. I think we were all hunkered down wondering if the trees would fall and hurt us. So glad to see everybody. And I want to just remind you that this meeting is part of a series that Doug has planned for us on religious liberty. And we are going to be covering, as we already have been, covering various topics on this important subject. And there are more to come. Next week, there will be a guest. Jessica Hawks is her name. She's from the Baptist Joint Commission. Baptists have a long history, just as Seventh-day Adventists do, in supporting religious liberty. And the two denominations often work closely together on religious liberty issues. So you will want to hear what she has to say. Tonight, I am going to cover the religion clauses of the First Amendment to the U.S. Constitution. Try not to fall asleep. That's maybe not the most gripping title. But those clauses actually have a lot to do with the freedoms that we enjoy. And as we were planning this series of programs, it seemed that we ought to at least spend one evening talking about the roots of our freedom. I want to start by thanking a guy named Doug Laycock. Doug Laycock is a professor at the University of Virginia Law School. He is a national expert on religious liberty, on the religion clauses of the United States Constitution. He was one of my professors years ago when I was at the University of Texas Law School. He now teaches at the University of Virginia. He has argued cases in front of the Supreme Court, including one I'll mention tonight in particular. He has written widely on the subject of religious liberty. If you were to make a list of the people in the United States who are experts on the law of this area, Professor Laycock would be on the very shortest of short lists. He was kind enough when I emailed him and said, I'm supposed to give a talk on the First Amendment, and I don't spend my time in my day job in the First Amendment. What would you suggest I study? He was kind enough to send me a speech that he gave in 2018 on this very topic at the Chautauqua Institution in upstate New York. A number of the slides I'm going to share with you tonight are extracts from that speech. I looked at other stuff as well, but really the core of what I have to say is would be found in that speech if you had the text to it. And he was very unselfish in sharing that with me. And he has looked through my slides and given me other suggestions. So I want to give credit where credit is due. Turning now to the topic for tonight, let's tell you where we're going. We're going to talk about the constitutional language itself, both in the First Amendment, and I'll mention briefly the 14th Amendment. Then I'm going to talk a little bit about some cases that have interpreted those constitutional provisions through the years, including changing ways that the judges have used to understand those words. And we'll conclude with reflection on where we are today in the field of constitutional interpretation in the First Amendment. It's good to remember that the United States was populated by Europeans nearly 180 years before we had the Constitution. The Constitution, 1787, you know, when the first European settlers came here. And you also remember that they fled religious persecution, but they were not particularly interested in giving freedom to people that disagreed with them. So the Puritans famously expelled people like Roger Williams, who was a Baptist or became a Baptist, went to Rhode Island. And the Catholics were not too popular in those days. They went to Maryland. That was originally a Catholic refuge. So there was, in the early days of our country, this view that freedom for me, but not necessarily for you. The country, though, did represent a departure from places where there had been established churches. And while we had established churches in a number of our states for many years, including into the 1800s, long after the United States Constitution was ratified, there was a spirit early on that, well, you might not be one of us, but we will at least tolerate you. We'll tolerate you. And over time, that evolved to a spirit of, okay, well, maybe we're all equal. Maybe your religion is as legitimate, has as legitimate a place in the public sphere as mine does. So if you think about the migration and thinking of our country, you would say they moved from places where established religion was the only legal way you could worship to a place in their thinking where this would be the preferred way, we'll tolerate people that disagree, to finally a situation where we would not have preferred religions. And that's what brings us then to the constitutional timing in the late 1780s. The country had moved closer and closer to this position of neutrality. When the Constitution was ratified in 1787, there were, of course, many people who felt it hadn't gone far enough to protect freedoms. And so very quickly, the first 10 amendments were promulgated and then ratified over a course of several years. And the very first amendment is the one we're talking about tonight, and the very first words of the very first amendment of the Constitution have to do with religion, and I've highlighted them there. Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof. Those are the words that are the foundation of religious liberty in America. That is the constitutional language. 2.5 lines on this slide. That's all there is. And understanding what those words mean and interpreting and applying those words has been the business of courts for many, many years. But you can see the words themselves. One thing you'll notice about these words is the very first word, Congress shall make no law. This amendment originally applied only to the federal government. This was not an amendment that restrained the actions of state governments that might have interfered with religious freedom. However, as I mentioned, after the Civil War, there were a series of Civil War amendments. They're called the 13th, 14th, and 15th Amendments of the Constitution. And the 14th Amendment has a due process clause that ensures that nobody's liberties can be taken away without due process of law. That's in the 14th Amendment. And as we'll come to in a little bit, the liberties in that due process clause of the 14th Amendment have come to be understood to incorporate the liberties that are given to us in our Bill of Rights. And so, because the 14th Amendment restrains states, it came to be understood after the Civil War that even though the original Bill of Rights only constrained Congress, they would also constrain state government. So since the Civil War, these clauses have applied to the states as well as the federal government. Who gets to decide what those words mean? Did we just sit around and talk about it and all have our own opinions? Well, yes, we do. We all have our own opinions. But the opinions that really matter are the courts. And in a very famous case, a very famous Supreme Court case in 1803, Chief Justice John Marshall wrote this opinion, which is studied by every law student that ever goes through school, that established the principle of judicial review of the constitutionality of statutes. It is emphatically the province and duty of the judicial department to say what the law is. If two laws conflict with each other, the courts must decide on the operation of each. So if a law be in opposition to the Constitution, if both the law and the Constitution apply to a particular case, so that the court must either decide that case conformably to the law, disregarding the Constitution, or conformably to the Constitution, disregarding the law, the court must determine which of these conflicting rules governs the case. This is the very essence of judicial duty. So since Marbury versus Madison, it's been clear that it's the job ultimately of the Supreme Court to tell us what the Constitution means. I mentioned the evolution briefly of the Constitution. 1787, the Bill of Rights came a couple of years later. Took 3 years to get the states to ratify all of those amendments, but by 1792, we had the first 10 amendments to the Constitution. The federal Constitution doesn't have very many amendments. It's hard to amend, and through the years, we haven't had that many, unlike some state constitutions, which have dozens and dozens of amendments. But the first 10 amendments came so quickly after the Constitution themselves, they're almost often thought of as part of the original document. The focus of the religion clauses at the beginning was primarily on this question of establishing a church. Should there be an established church in America? No, there should not. How would it be stopped? With the no establishment clause. The founders did not want the government to fund churches, and they did not want the government to designate a particular denomination. And many of these ideas developed in the state of Virginia. George Mason there was a Virginian, and of course Thomas Jefferson and James Madison, some of the great thinkers underlying the Constitution. In Virginia, there was an established church, the Anglican Church. And that was a very British tradition in Virginia, and it was not a popular tradition in the minds of those Virginia founders. George Mason, who's pictured here, came up with the phrase free exercise of religion. Remember, the clause has two parts. Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof. Remember those two clauses, establishment and free exercise. You're going to see how the cases looked at those through the years. And George Mason is the Virginian who came up with the free exercise wording. There was never really a lot of dispute over the idea that people should be allowed to freely exercise their religion, unlike the Establishment Clause, which was a bit more controversial. The question with the free exercise clause has always been, does it just protect what you believe, or does it also protect how you might act out your religion? There's never been much controversy about the fact you can believe whatever you want, but deciding how far you can go in exercising your beliefs has been something the court has had to wrestle with. There are other sources of religious freedom in our country, primarily state constitutions. They have their own free exercise and establishment provisions, depending on the state and the time it came into the United States. And there were some state constitutional cases in the field of religious freedom prior to the Civil War. Some of them granted religious exemptions and some of them didn't. It's difficult to generalize about how those states came out. And we're not talking about the state constitutions tonight. So I'm going to just focus on federal cases, and I'm only going to focus on cases that came to the United States Supreme Court. The very first case that came to the Supreme Court involving the religion clauses did not come there until 1878, almost 100 years after the Constitution itself. And that was the Reynolds versus United States case. Now, this was a case in which a Mormon had deliberately violated a local law that prohibited polygamy by marrying multiple wives, and had done so for the purpose of testing the constitutionality of the prohibition. So when he was prosecuted for violating the statute, he raised the defense that polygamy is part of my religious belief, and I should be protected in the exercise of that belief. But the Supreme Court held, in an opinion that I think a number of scholars today think is not really the nicest wording and maybe not even the right result, but it held that polygamy was not even a religious practice, according to Western tradition. It wasn't even a religion. So therefore, the First Amendment had nothing to say about it. We don't even have to get to the question of whether you are entitled to the free exercise of your religion, because polygamy is not a religion. And the court drew a clear line between believing and acting. Now, here's the language of the opinion, and I'm going to have to put my glasses on and read it from here for you because I cannot see that. But it's worth dwelling on this just for a moment. This is part of the Supreme Court decision in 1878. Laws are made for the government of actions, and while they cannot interfere with mere religious belief and opinions, they may with practices. Suppose one believed that human sacrifices were a necessary part of religious worship. Would it be seriously contended that the civil government under which he lived could not interfere to prevent a sacrifice? Or if a wife religiously believed it was her duty to burn herself upon the funeral pyre of her dead husband, would it be beyond the power of the civil government to prevent her carrying her belief into practice? So here, as a law of the organization of society under the exclusive dominion of the United States, it is provided that plural marriages shall not be allowed. Can a man excuse his practices to the contrary because of his religious belief? To permit this would be to make the professed doctrines of religious belief superior to the law of the land, and in effect to permit every citizen to become a law unto himself. Government could exist only in name under such circumstances. So, our Mormon did not win his case, and he had to suffer the consequences of his decision. But after this opinion in which the court said you can believe whatever you want, it really continued to come down hard on Mormons. It would not even protect Mormon belief. In 1890, the court upheld a test oath that prevented Mormons from voting. The oath just expressed what they believed, wasn't an action, but they couldn't take it. I think part of the oath said they didn't believe in plural marriages. And if you wouldn't say that, you couldn't pass the oath and you couldn't vote. That was upheld. Congress revoked the church's corporate charter, seized all church property except for actual places of worship. And the court upheld those actions, the Supreme Court did. And it didn't take very long thereafter for the Mormon church to abandon its doctrine on plural marriages. The Supreme Court went silent after that. There weren't any significant free exercise or establishment cases after this spate of Mormon cases in the late 1800s until the 1930s. But since Reynolds in 1878 and through 2006, there have been 115 religion cases decided, and many more in the last 16 years. I don't have the total since 2006. But if you think that there weren't too many cases until the 30s, and there's been 115 since then, and a bunch more since 2006, you can see how active litigation has been in the field of religious liberty. In the 1930s, what had happened in our country? Franklin Roosevelt had been elected. We were in a depression, and Roosevelt enacted a series of legislative moves to bring the country out of that depression, which the Supreme Court struck down again and again and again under the line of judicial thinking that existed at that time. And Roosevelt got so mad about it, he decided he would support legislation that would expand the Supreme Court so he could add justices that would uphold his legislation. Many of those decisions had been decided by a 5-4 vote. And a justice named Owen Roberts was often in the side that struck down the New Deal legislation. But as the movement gathered momentum to pack the Supreme Court, which is what opponents called it, Owen Roberts switched his vote and started voting with the 4 that had been in the minority. And this is called the switch in time that saved 9, because when Roosevelt started winning the cases, then the pressure came off to expand the court. And then some of the older justices retired, and new Roosevelt appointees came on the court, and there became a new era in judicial interpretation as to how far the Constitution could go or could not go, a new era. And the First Amendment cases were part of that. So we see this in the 30s beginning to change, the thinking beginning to change. Many of these early cases in the 30s involved the Jehovah's Witnesses. They were very unpopular, they were very active, and they were sort of a persecuted group. And so cities and states would pass laws trying to repress the ability of the Jehovah's Witnesses to witness to their faith. And in one of the first cases involving the Jehovah's Witnesses, called Cantwell versus Connecticut, the Supreme Court held that, remember I told you about that Civil War amendment, the Supreme Court held, you know what? The First Amendment applies to the states. So 1940 is when that happened in this Cantwell case. And this involved a statute that prohibited door-to-door solicitation without prior approval by a state official. And the official's job was to decide whether the religious solicitation that was being requested was for a valid purpose or not. So you had a state official being asked to pass on the legitimacy and validity of a religious belief. The state said, well, this is designed to protect against religious fraud. We don't want people out asking for money if they're fraudsters. But the Supreme Court said, listen, that statute is targeted at Jehovah's Witnesses. It's hostile to religion. If you wanted to have a general regulation of solicitation, that'd be one thing. But you can't have a solicitation statute that's really set up just to stop a religion from going door to door. And so the statute was invalidated. And significantly in this 1940 case, the Supreme Court moved away from this view that belief is protected but actions aren't. Remember the Mormon case. You can believe what you want, but not your actions. Now the Supreme Court says, no, actions can be protected. There can be circumstances in which your religious actions are protected, not just your beliefs. They're not going to be absolutely protected, but there will be a presumption that they are protected. And this represented a shift in the thinking of the free exercise analysis from those earlier Mormon cases. Modern free exercise analysis started 23 years later with a very famous case called Sherbert versus Werner. And this case involved a Seventh-day Adventist, so you'll be particularly interested in this. Mrs. Sherbert worked at a textile mill in South Carolina, and she had joined the Seventh-day Adventist Church in 1957 while she was working at that mill. 2 years later, in 1959, the mill went to a 6-day work week, which included working on Saturdays. She quit because she wouldn't work on Sabbath, and she couldn't find another job. She looked at some other mills in her town, and they all had work on Sabbath. So she applied for unemployment compensation, and the state denied it. The state said, you're healthy, you can work, we're not going to give you unemployment compensation. The Supreme Court disagreed with the state and held that to deny unemployment compensation to Mrs. Sherbert violated the First Amendment, because the reason that she wanted it and had applied for it was because she had lost her job because of her religion. And the court held you can't deny somebody unemployment compensation based on their religion, unless you have a compelling interest. This is a very high standard of review. For a statute to be analyzed under the compelling interest standard makes it almost impossible for the government to win. It's very hard to show that your interest is so strong and so compelling that the rights of the person who will be affected are less important. This is what we call the strict scrutiny test, and that's what was applied in Sherbert versus Werner. It reaffirmed this analysis, the Supreme Court did, a few years later in a case called Wisconsin versus Yoder. This was a case in which the Amish community wanted their kids to stop going to a formal public school after the 8th grade. But Wisconsin had a rule that said kids had to go to school until they were 16, until they finished their 16th year. Well, there's not a lot of difference between 8th grade and 16. There may be a year, 2 years, year and a half, somewhere in there. And the court held that the state had not shown a compelling interest to force kids to go to school that extra 1 or 2 years if they had a religious objection to it. And so it said the state can't show the 2 more years matter, and we're going to strike down the statute. At least let the Amish kids not have to go to high school. So that was the state of the free exercise clause in the 60s and 70s. And yet, even so, it wasn't applied very often. I don't know if there weren't a lot of cases in it, but the court really held that from 73 till 1990, only 3 times had it been violated. Now we come to 1990. There was a sea change in free exercise jurisdiction, and it occurred in a case called Smith versus Employment Division. Now, the Smith versus Employment Division case has facts very similar to Sherbert. Remember, she wouldn't work on Sabbath, and so she lost her job and sought unemployment compensation. In this case, Smith worshiped in religious services that involved the use of peyote, and I put a picture of it there for you. It's a little cactus that apparently if you chew hard on its buds, they're hallucinogenic. And this apparently had been a practice in certain Native American religions for as long as anyone could remember. It is a legitimate religion, meaning that it's not just something this guy dreamed up in his house. But when his employer found out that he was using peyote, they fired him. And so he applied for unemployment insurance, thinking, well, surely I'll win, right? I've read the Sherbert case. I should get unemployment. I lost my job for my religion. But Justice Scalia, who wrote this opinion, a conservative justice, I think by that time was starting to get concerned about the proliferation of religions in America. We got all kinds of religions, and what are we going to do here? Everybody's got a religious belief. What happened to the good old Christian days? What happened to the good old Judeo-Christian country? What are we going to do with all these Native Americans that want to chew peyote and do other kinds of stuff? So the Supreme Court in this case abandoned, or they didn't formally overturn Sherbert, but they said, look, if the law that is being applied to an individual is one of general applicability, it's not targeted to religion, and if it is neutral about religious practices, then it's going to apply even if it has the effect of interfering with someone's religion. So here we had a law that said you can't use peyote. It applied to everybody. It was neutral. It hadn't been invented to attack this particular religion. And so Mr. Smith did not get unemployment benefits because he was subject to that law. That was a huge change because now the great fear was free exercise claims were going to never be acknowledged again. The strict scrutiny test didn't seem to be applied. The state didn't have to show a compelling interest. It didn't have to do a balancing. All it had to do was pass a law that would apply to everybody, and then religion was affected. It was a worrisome case. In fact, it was so worrisome that Congress immediately swung into action. I hope you can read this, but I'll tell you about it, and enacted the Religious Freedom Restoration Act. And this statute, this federal statute enacted under the Clinton administration, restored the Sherbert test as a matter of federal law, not Constitution, didn't go back and amend the Constitution, but it created a statutory right that reimposed the strict scrutiny compelling interest case. It passed unanimously in the House of Representatives. Can you imagine anything passing unanimously today? But it passed unanimously in the House, Democrats and Republicans, and 97-3 in the U.S. Senate. It inspired a number of states to enact their versions of the Religious Freedom Restoration Act, and they did so because fairly early on, you'll see that box in the middle of the right-hand side of the middle column, the Supreme Court held that this statute could not apply to states, and I'm not going to get into the analysis that the Supreme Court used, but it said Congress didn't have power to control state actions using this statute. It could only constrain the federal government. So many states said, fine, we'll enact our own statute. That momentum ground to a halt. There's, I think, over 20 states with their own, but it ground to a halt. It got chewed up in the growing gay rights movement, which was very concerned about whether these statutes were going to give religions too much power to discriminate against the LGBTQ community. So the Religious Freedom Restoration Act in the states got balled up in what we still have as a culture war in this country between some understandings of Christian teachings and the interests of the LGBTQ community. And so the effort has stalled. But it still exists as a federal statute, and it does in many states. Members of the current Supreme Court have reservations about the test in Smith. The current court is fairly conservative, and it is not sure that they like the Smith case, even though it was written by a conservative justice, because they recognize that it sets a pretty low bar for a state to get over in order to regulate religion. But the court hasn't settled on a free exercise framework to replace Smith, and so in the meantime, they seem to regularly find that laws are not generally applicable. Remember, that was one of the requirements of Smith. If the law is generally applicable, it will apply to religion. So what the court does now is it looks around for exceptions. And if there's an exception to a law, and most laws have exceptions, then they say, okay, well, Smith doesn't apply to this because I can see an exception. Here's a good example of this. The case last year, Fulton versus City of Philadelphia. In this case, the City of Philadelphia had refused to place kids for adoption with Catholic Social Services. And they had refused to do so because Catholic Social Services in Philadelphia would not put kids in families headed by a gay couple. It violated the religious convictions of Catholic Social Services to do that. And because they would not place kids with gay couples, Philadelphia said, well, fine, we're just not going to let you have any kids to place. But the court in that case struck down the city's actions, and it said that even the power to grant exceptions was enough to make the law not generally applicable. I don't think in Philadelphia they had actually granted exceptions, but they had the power to give an exception. And the court said, all right, it's not generally applicable. The low standard of the Smith case doesn't apply, and we will apply the compelling interest standard. And they concluded that the city did not have a compelling interest to prevent the Catholic Social Services from continuing to place kids for adoption. So I think what's happening with Smith is it's being bit by bit sort of ignored and eroded, and free exercise claims have really come back into their own in the last few years, and we'll see a bit more about that in just a minute. I'm getting to the end, believe it or not, so if you have questions, be thinking about them. You can send them in online, of course, and Doug will read them, and would love to have a discussion. But this takes us to the gay wedding cases. You read the newspaper so that you know there are vendors that do not want to participate in providing services for LGBTQ weddings, whether it be making cakes, building a website, or taking pictures. What will the court do to resolve the tension between the civil rights of LGBTQ members and the religious rights of vendors who feel like participating in providing services violates their conscience? Well, it's going to be interesting to see what happens, and part of this is going to evolve against the backdrop of the Bob Jones case. In the Bob Jones case, the Supreme Court removed a tax exemption from a school that prohibited interracial dating. The school said, we have a religious conviction that the races should not mingle, should not date, and the court said, well, in that case, you can't keep your tax exemption. That's a violation of law, and your religious reason for that is not important enough to overcome the compelling interest that the nation has in eradicating racial discrimination. Will that be a precedent that the court follows in the gay cases and hold that eradicating discrimination against the LGBTQ community is compelling enough to override the religious objections of these vendors? We don't know. We will just have to see. Does the state have that compelling interest? Who has the better of the argument when it comes to a compelling interest? And of course, those cases have trickled up to the Supreme Court. They had one case, the very famous Masterpiece Cake Shop case, where the state of Colorado had said a cake maker must provide a cake to for an LGBTQ wedding, and the court struck that down and sent it back to Colorado because one of the commissioners had made some very negative statements about religion in history. They weren't necessarily false statements. He said, for example, that religion had supported slavery. Well, that's historically true. And he said some other things about religion, but the court said, aha, we see hostility to religion. This law was motivated by hostility to religion. We're not going to allow that. Now, you've got to figure that state policymakers will be careful about what they say as they enact these laws in the future, and there are cases percolating up to the court that won't provide such a convenient way for the court to avoid the issue. One more interesting set of free exercise cases before we turn quickly to the Establishment Clause, which will go a bit more quickly, are the COVID cases. We experienced that here in Florida, throughout the country, in our own congregation, with directives to not meet. Don't meet in church. Don't meet in large gatherings. Well, there were some churches that opposed that. They said telling us that we can't come together violates our constitutional rights. Those early cases came up to the Supreme Court in different ways. I'm not going to get into the procedural posture of those cases. They weren't all fully developed, but they got in front of the Supreme Court, and the early church closer cases over the last couple of years went in favor of the governments. Often it was a 5-4 vote, but the court deferred to the judgment of local officials as they attempted to stem the pandemic, and they did not intervene to disrupt decisions that churches should close. Then Justice Ginsburg died and was replaced by Justice Amy Coney Barrett, and the cases since that switch in the court's composition have tended to favor the churches. And they have done so based on this non-neutrality standard that I talked about with Smith. Some of the cases have said, look, you are letting casinos stay open, but not churches. That's not a neutral application of a rule. You're letting shopping malls stay open, but you're closing churches. That's not neutral. And there's counter arguments to that, but I'm not going to get into that. Not every gathering is the same, but as the dissenters pointed out. But the point is that the COVID cases have become examples of a very robust application of the free exercise clause. Now, turning to the Establishment Clause. Remember, that's the part of the First Amendment that says Congress shall make no law respecting an establishment of religion. That was the clause designed to keep the government from having an official church, from having the government fund a church. So it's a different part of the amendment, but an important part. It was first applied to the states in 1947 in a case called Everson versus Board of Education. In that case, a New Jersey taxpayer sued the state Board of Education because the Board of Education was reimbursing parents for the transportation costs of their students going to school, whether they were going to a public school or a private school. If you got on public transportation, you had a subway cost or something like that, the state would reimburse you for that, irrespective of where your child went to school. The court decided in that case that that was okay, that transportation expenses were sufficiently removed from a religious function that it was okay for the state to fund that. But the court was very clear, both the majority and the dissent, that this wall of separation was quite important. This is where I think maybe the first time the wall of separation metaphor gets used in a Supreme Court case. That, by the way, was a metaphor invented by Roger Williams way back when he was expelled to Rhode Island to describe the way in which the church, the garden of the church, should be protected by a wall against the wilderness of governments. And that wall of separation metaphor is not in the Constitution, but it's often the way people talk about these cases, and partly because the Supreme Court talked about it that way in Everson versus Board of Education. The Establishment Clause cases sort of culminated in a case called Lemon versus Kurtzman in 1971 with a test that asked three things. A law will violate the Establishment Clause unless it has a secular purpose, it does not have a principal or primary effect of advancing or inhibiting religion, and it does not result in excessive entanglement between church and state. That was the three-part Lemon-Kurtzman test. If those three things were present, secular purpose, didn't promote or inhibit religion, and didn't promote excessive entanglement, the law was okay. Otherwise, it would violate the Establishment Clause. Pretty quickly, people started criticizing this test. It was hard to understand and apply consistently. How do you know when something's excessively entangled? How do you know what the purpose of the law is? Who do we listen to when we ask what the purpose was? And the Supreme Court has been critical of it and has shifted away from it to really a focus on what were the traditions and history in the country at the time the Establishment Clause was enacted. And so we see cases allowing prayers in public meetings. We see cases allowing religious objects to be displayed, like the Ten Commandments. The Christian cross is allowed on public lands. And on grounds that, hey, these were things in place at the time of the Constitution. Of course, as we've talked about, some of that history and tradition was pretty negative and hard on people that didn't see things the way the majority did. But the court has shifted to a view of the Establishment Clause that focuses very much on traditions. More recently, there was talk that maybe they had actually abandoned this three-part test in this Shurtleff versus City of Boston case decided just a few months ago on May 2. In that case, the court held that Boston had violated the free speech clause of the First Amendment, not the religion clause, but the free speech clause, by blocking a group that wanted to fly a Christian flag in front of City Hall. So they allowed the Christian flag to fly in front of City Hall, but they couldn't agree among themselves as, well, have we really abandoned Lemon or not? What's the status? We're going to let the flag go, but what is our framework of analysis here? Then a month later came the Kennedy versus Bremerton School District case, which I have up there on June 27. You've probably read about this in the paper. A high school football coach at the end of a game would lead prayers at the 50-yard line, and school officials told him to stop it. We can't have prayer in schools. That's an establishment of religion. Remember the school prayer cases from the 60s. When you have a teacher leading prayer, the Supreme Court held that violates the Establishment Clause. Well, now we have a high school coach leading prayer. Why isn't that violating the Establishment Clause? And so the high school said, you need to stop it. But the Supreme Court held, no, he doesn't have to stop it. The majority held, your prohibition about post-game activities applies only to religion. You're letting the coaches do anything else. The district had said, hey, the coach needs to pay attention to cleaning up after the game, putting the equipment away, stuff like that. And the court said, no, you're not stopping the coach from doing anything else that might be distracting. You're only stopping them from praying. And so that law has been upheld, and conservative evangelicals are very excited about this case and looking very hard at ways to expand it and maybe even try to attack the old school prayer cases and see whether the court would overturn them. Just three more quick cases on the Establishment Clause. Also this year, June 21. Remember, I told you about that first case in the Establishment Clause where the question was, could we pay for public transportation? And the court said, well, that's not very religious. That'll be fine. Here we have a case where the court said state has to fund a religious school. You can't not fund a religious school. That doesn't violate the Establishment Clause. There was a Maine law that prevented students at a religious school from getting tuition assistance. And of course, they would have thought, well, that violates the Establishment Clause, right? We were told it was okay to fund buses, but not religious instruction in schools that do that. But the court said, well, actually, if you don't fund that school, you're violating the free exercise of that school. So we've seen a big expansion of free exercise and a very big shrinking of Establishment Clause. You know about the Dobbs opinion that overturned Roe versus Wade. It will be interesting to see if some religions argue that their religion requires abortion in certain circumstances. How will the court resolve that? And then lastly, and most recently, I'll mention the Yeshiva case. Yeshiva University is a Jewish university that is orthodox in its beliefs, and those orthodox beliefs do not lead it to recognize LGBTQ student groups on campus. It has other student groups, but won't recognize an LGBTQ student group. And the LGBT group sued and argued that this was a violation of their rights. And the Supreme Court, a couple weeks ago, said, look, we're not ready to hear this case. There's 5 justices said, you got to keep litigating in New York. Finish your work in New York, and then we'll hear it. But 4 justices said, no, we'll hear it now, and we think yeshiva is absolutely in its rights to block a recognition of an LGBTQ group. That's their religious freedom. So we already know yeshiva's got 4 votes. And Roberts and Kavanaugh were part of the group that said it's too early, and both of them are conservative. So I think it's likely that when it gets back, either or both of Roberts and Kavanaugh will join the other 4. All right, bringing it in for a landing now, 3 summary slides, and I will be done. In summary, in the past 80 years, the Supreme Court's understanding and application of the religion clauses has evolved. Point number 1. Point number 2, this is partly a function of varying judicial philosophies represented by changeover of justices as time passes. You can see those words at the beginning of my talk. It's like trying to read a Bible text. Different people will read them differently, and justices are no different than anybody else as it comes to reading texts, in this case a constitutional text. And it could be expected that words written in the late 18th century might be open to evolving understandings in modern times. It's been a long time, and things are different now than they were in 1787. We've seen that in the Establishment Clause cases, the Lemon test has been rejected. There's been a de-emphasis of the dangers of coercion or state endorsement in favor of a focus on tradition. And of course, the nation's tradition is very Christian-centric, and so I think we can expect, at least with the current Supreme Court, to see a much more relaxed view towards objections based on the Establishment Clause. In the case of the Free Exercise Clause, there's been an effective rejection of that easy-to-satisfy Smith test in favor of greater deference to free exercise claims, and the result of that has been an increased protection for traditional Christianity. Finally, it's been the case for a while that outright hostility to religion will not be tolerated. That is very clearly exemplified in the Church of Lukumi by Balu Ai versus City of Hialeah. This is the case that Doug Laycock argued, one of his. And just pause real quickly. This was a case in which I think Miami, or one of its suburbs, had passed a law against the sacrifice of animals in religious ceremony. There's a religion, and I can't remember what it is and where it comes from, but live animal sacrifice is part of it. And it was very clear that the statute that said no killing of animals was directed at this religion. You could kill an animal to eat it. You could go to a restaurant and eat an animal that had been slaughtered. The city even admitted that the sanitary conditions around dumpsters was much worse than what was caused by the sacrifice of these animals, and the Supreme Court said, you know what, that statute cannot stand. That's an obvious interference with the free exercise of the religious practices of this group that's sacrificing animals. Where will the line between beliefs which are fully protected and actions which are partially protected be drawn as we go forward through the culture wars in our country? That remains to be seen, but watch for that. I would say in conclusion, though, this particular Supreme Court, is not by any means hostile to religious practices, certainly not to religious beliefs. And the extent of protected practice always remains subject to line drawing and balance. And with that, I will pause. That is a quick overview of just part of religion case jurisprudence in the Supreme Court right now, but hopefully gives you a little bit of point of reference for some of the other discussions that we'll be having in this series. I don't know if any of you have questions or there's questions online, but I'll just pause and see. I see none. All right. But I do see you're still awake, so you may not have questions, but you're still awake. All right, then I think that we're ready to close, and we'll bow our heads for a word of prayer. Father in heaven, thank you for this great charter of freedom that we have in our country, the Constitution. And we're mindful of the oath that presidents take to honor and uphold the Constitution, and of the dangers that are created when we're casual or careless about its protections, wherever they're written. And we're also humbled by the responsibility each of us has in our own spheres to uphold the constitutional order and to claim and maintain the rights that this document gives us. Thank you in particular for the religion clauses and the way they've allowed our church to flourish, which has not always been in the majority and yet has been allowed to grow and worship in our ways. Thank you for the ministry of Mrs. Sherbert, who was such a great witness for you and the Sabbath in the case that she brought nearly 60 years ago. Be with us now as we return to our homes and continue to keep us safe, and keep your sheltering hand on the many, many thousands in our state and in the Southeast who have suffered and continue to suffer from the consequences of Hurricane Ian. In Jesus' name we pray. Amen.